Um, we've
Sorry about
had
that.
a couple of meetings, and the most recent was of the small work group that was addressing one of the issues. And so we'll take that up in a bit, and Jim will probably lean on you a little bit on that. Um, I'm sorry I couldn't be there for that. I was on an airplane. Um, but we also just sent out the memo about proposed work group topics and the schedule for our proposed schedule for our legislation, and I thought we could go through that and then talk about the issues that we're still comfortable moving forward on. Maybe talk about whether this is the list priority that we want. If there are any people who are interested in a specific topic that you know you're going to be someplace exotic when one of the months that we have scheduled that topic, it would be helpful to know so that we can make those adjustments as well. Um, Unless, of course, you want to participate, by satellite. Um, and uh, and I thought that what Amy did and Kara did was they prepared sort of the background for us about this specific work group, and what kind of was left to be done or left to be considered, if not done, um, concerning the municipal and justice court legislation and any proposals that we want to make. One of the ones that we had talked about originally was something that Representative Wallen had brought up, having to do with the certification of justice and um, municipal court judges and judge applicants. And she has since withdrawn that request for us to consider in giving it further review, and in conversation with some of the stakeholders, decided that that was not something that we had to take upon ourselves. We weren't sure if we had all the right stakeholders in the room, but also it seemed like something that maybe has already been addressed adequately, at least insofar as the policy questions that we were asked to take a look at. So we were appreciative of Rep. Wallen for getting us into the conversation, and also, frankly, for getting us out of the conversation, um, so that we could focus on some other things. Um, and so I just thought that what we could do is go through those areas in the draft schedule and see if those still resonate as our highest priorities. Um, if there are other things that people have, since come up with, my own suggestion is going to be that we not take on new topics unless we are comfortable that we're dealing with the issues that we were asked to deal with. And if we get through that list, then if we have time before the end of our 1 year designated time frame, then we could look at the other subsidiary or other areas, topics of interest. So the first one has to do with the waiver process for FED undertakings in local courts that mirror circuit courts, and we had set that for November, December. The second was whether current service requirements on district attorneys, when they're not involved in a case directly, are sufficient without creating additional burdens. The third was whether justice courts should have the option of becoming courts of record. The fourth was whether violations appealed from the local court to the circuit court and then to the Court of Appeals should proceed under Chapter 19 or Chapter 138. The next was whether the limitation on appeals to the Court of Appeals in the prosecution of municipal offenses are unduly restrictive. The next is whether the records of abolished local court should go to the circuit court or the city or county. The next was a proposal raised by John DiLorenzo, whether the city of Portland should have a municipal court system. And that was not on the original list, but it's one that we've been asked to look at. And the next was when and how to transfer cases between local courts and circuit courts. So I thought what we would want to do is talk about if this is our universe, and whether we have the bandwidth to address each of those things. As you probably remember, we actually had a small group express interest in talking about the waiver process for FED undertakings. So we put that as the first in line, and we'll have hopefully time to discuss that today with Jim and any others who are in that small work group. And then also whether this order that's proposed, where we have months set aside for each topic as needed, if that works for everyone. So do you want to just kind of start with the first, or do you want to just, anybody have any strong thoughts on any of these in terms of their continued interest, and also a draft schedule for each of the topics?
Judge James, Heather has her hand up. I'm not sure if you can see that.
Oh, I can't see it, but Heather.
Had a clarifying question, and it's kind of just picking one from in the middle of the list, if that's okay. It's not very linear, but I was wondering whether anyone might have more information about the desire to take up justice courts becoming a court of record. The reason I ask is I thought that there already was a statute that contemplated that providing a process. And so I wasn't totally sure what this was proposing.
That is a good question. Amy?
I was going to say, Kimberly's got her hand raised.
Okay.
I don't know if that's in response to the original question or something else.
Yeah, I think I think what this has to do with is there's a prohibition right now on justice courts becoming a court of record if they're within 50 miles of a circuit court. And so there are justice courts that are courts of record. I don't think there's very many. But I think the idea here was just to expand that. And I can't recall, I can't recall who it was who brought it to the work group, but I know that there was a legislative proposal last session that Justin Kidd had been Judge Justin Kidd had brought to the table. So I think it was a desire to have more conversation about that.
That answers my question. Thank you.
And I can add a little bit more to that. I'm meeting with Justice Kidd or Judge Kidd tomorrow or Monday. I'm not sure which. We haven't confirmed yet. And the conversation did originally stem from a conversation with Judge Britton, Judge Cross, and Judge Kidd, and that's where it came from.
Okay. And I guess the question to clarify, the question is whether there's interest in eliminating the prohibition, or is it a question of whether or not the 50 miles is appropriate? I'm not clear what the I'm not clear what the proposal would be.
My understanding from the conversation about a year ago was, is the prohibition, the 50-mile prohibition, is that necessary? But I would defer to the judges, the Muni and Justice Court judges, on the details of it. I don't want to speak for them, but they were the ones who raised it and seemed very interested last year in continuing that conversation.
Okay.
And that is what the legislation did, was it just removed that prohibition. And I know that there was I did some legislative history research, and I think that Justice Kidd did research as well. And it was a little confounding. There wasn't really much in the legislative history to explain what the legislature was thinking when they made that decision. I'm not entirely sure what the actual reasoning is.
And Kimberly, is that the question of whether you don't know what they were thinking when they put in the prohibition or when they took it out?
That's right. They just didn't really talk about it when they put the prohibition in. There just wasn't, it was a bill that had a whole bunch of different provisions in it, and they just didn't really talk about this particular one.
Jim.
Yeah, I've spent quite a bit of time with this law, and I think I was even Judicial Department's representative monitoring the bill when it originally passed in the 70s. And one of the oddest, the 50-mile limitation originally applied to both municipal courts and justice courts. And there's nothing in the legislative history, either the oral testimony or the written materials that came in with it, explaining why do we need this 50-mile limitation, or what purpose does it serve? And then a bunch of years later, again without explanation, an amendment was offered to remove the 50-mile limitation as to municipal courts. Once again, there was no oral, and that amendment was one of several others that were apparently of more importance to the sponsors, because there was discussion of the need for the other amendments, but no mention of why the 50-mile limitation was being removed as to municipal courts and not removed as to justice courts. That bill ultimately passed. So we're in this situation where the 50-mile limitation has been retained as to justice courts and eliminated as to municipal courts. So we have a fair number of municipal courts of record, and I don't think we have a single justice court of record, because my understanding, most or all of them are within that 50-mile radius of the local circuit court. So it's a real conundrum trying to decide whether we should change the policy, because we don't know why the 50-mile limitation was originally imposed as to both justice and municipal courts, and we don't know why it was removed as to municipal courts. So I would be keenly interested in hearing from the Justice Court folks, if there are justice courts that would like to become courts of record. I certainly hope we allow them to do so.
Can somebody remind me of what the funding is for justice courts? Like, who funds it?
My understanding is it's cities and counties, and for the local courts. Kimberly, by putting your hand down, I think that you're probably agreeing with me.
Yeah, for the municipal courts, it's the city, and for the justice courts, it's the county.
And yeah. And I did get an apology from Tim at Association of Oregon Counties. He's at a conference Monday, Tuesday, Wednesday of this week. So we can check in with him. He just couldn't make it today.
Okay. Okay. Well, it sounds like that is something that we still should have at least on our list, and then determine the level of passion by the people who are most affected by it. Which I would think would be those courts, and also the counties, just because there would be a financial that attaches to it potentially, in terms of a court of record, and it kind of dovetails into one of our other questions about where the records get kept and how they're maintained, and I expect it may also then affect the appeal of those decisions. If you are appealing from a court of record, the appeal might shift in what the appellate court is going to consider, as opposed to what a circuit court would consider from a decision that's not doesn't have a record. So those might be the major issues I think we'd be looking at. Okay. Monty.
I think it's a good start for a schedule, I think it will be probably pretty tight unless we keep strictly to our proposed areas, because
Mhm.
I think we could very easily dovetail off. So we'd have to stay right on track, I think, to keep with the schedule. But I think it's a good, probably the best first attempt for a schedule that we could do at this point.
Thanks. Yeah, I agree with the clear need to stay on task. And that's asking a lot of all of us who are creative. But I think that we're up to it when we consider kind of the urgency of the mission and the time frame we have to work within. Amy.
Monty, a quick question for you. You are the next, since you are the DA here, you're kind of the next topic, which would be in December. And I just wanted to check in with you. I know we talked earlier this fall, maybe late this summer, but I wanted to check in with you about that timing and if December and January is going to work for you to kind of have those conversations.
I think it will, because I'm
Okay.
having to go back and try to get caught up to speed, but I think it would be a good time period, and it definitely is something to make sure of, because I know that's probably a significant consideration for district attorneys when, if it's cases getting appealed that we're not involved with, and there's a notice requirement to notify the DA. I mean, I think it'd be good to look at making sure it's not creating unnecessary hardships.
Mhm.
Okay.
Can you give me just like a 1 minute summation of what kinds of cases would be appealed from that you need to know about, but that you're not originally involved in?
My understanding is, so when a case goes to a municipal court that's not of record, it goes through, and let's say it goes through trial. Well, the defendant has a right to appeal it de novo to the circuit court.
Uh-huh.
When that happens, though, the district attorneys generally by practice do not take up the case. My understanding in the places I've been at have been the city prosecutors will continue to follow that case and handle it in circuit court. And so
Okay.
one of the things I want to make sure of, and I haven't had a chance to finish reviewing the bill, but making sure, for example, like if notice requirements related to that kind of an appeal, if it's requiring it to go to the DA's office, it doesn't make much sense considering it would be the city prosecutor handling the case. And so I
Mhm.
know in talking within our association, one of the concerns is if we have a notice requirement where something like that happens, where it's required by the statute to go to the DA's office, but the DA's office is not involved in the case, if that's going to create potential log jams or things getting missed because the party that needs the notice isn't getting the notice. And then
Right.
because the DA is not involved at all, now they're having this notice, and it's kind of this, okay, we've received this notice. Do
Why?
we just sit on that hand grenade, or do we need to get it off to somebody else before it goes off?
Okay, got it. Emily, thank you.
I think that with the municipal court and the city attorney that we figured all of that out with the last law, and that the city attorney needs to be served or the representative needs to be notified. But for the justice courts, if an attorney is going to appear for the state in justice courts, it is the DA that appears, and so they would be the one that needs to be served, right?
Is someone talking that I can't hear?
I heard the same thing. I'm not sure.
Okay. So, Monty, do you know if the justice court is, if the DA is served when a case is appealed from justice court to circuit court?
You know, I don't. The counties I've been in, only one of them I can recall appeared in justice court for prosecutors. I've been in Union County, Klamath County, Umatilla County, and Lane County. And Klamath was the only one where the prosecutor would appear, and that was usually on, and this has been more than 15 years. I want to say it
Yeah.
was dog cases, maybe some traffic violations.
Okay.
And so a lot of the
They
other DA's
appear in
offices,
Washington County.
they do appear in
They-
Washington.
Yeah, they have a DA day once a month where all of the attorney cases are scheduled and the DA negotiates with the attorney.
In justice court?
In Washington County Justice Court with Judge Dan Cross.
Okay.
I would agree with Emily that if the DA is appearing in a justice court case that gets appealed and they're the ones going to be handling it for the appeal, it would make sense for them to get notice.
Yeah. Okay. So it sounds like that might be another question as well that Judge Cross we might just find out if we can from the justice courts, if that's an anomaly, or if that's actually something that happens in other counties who have justice courts. So,
Okay. And just a heads up, Jessica's got her hand up.
Jessica, yes.
I would just encourage people to review sections 10 and 40 of House Bill 2460. Yes, Lindsay has just added that in the chat as well. Section 10 is dealing with the service of the notice in justice courts, and section 40 for municipal courts. And we did try to strike the balance, meaning that the appealing party always has to serve the adverse party. And then if the case is brought in the county's name and the defendant has not already served the county attorney is then served. And then if the case is brought in the state's name, the defendant kind of as like a default serves the district attorney if that district attorney has not already been served. And that there's a similar provision for the municipal courts, but with the city attorney. So there was an attempt to draw that balance and not cause those extraneous notices to be served on the DA's office, but it certainly could be, clarified if this still is causing problems or tweaked in some way. But again, I would encourage people to look at those two sections.
Okay, so that might be something that we can look at, and that Moni, if you can take a look at and see and check with your association and see if that addresses it or if it needs any fine tuning. Great, thanks. Amy.
And I did want to flag that this particular issue was added to the report for 2460 in November of 24.
Okay.
And then there was a conversation with, oh my gosh, Healy, Clackamas County, who's I think is the legislative chair for ODAA. And so he might have some background on this. And I think that it's possible that what is currently in 2460 might fix a lot of these things, but we weren't sure, and we wanted to preserve the opportunity to talk about this. So
Okay.
there might be, just like Jessica said, there might be tweaks that are needed. But I did want to flag that there were conversations after the report was published, which included this, because we wanted to preserve the right for the DAs if there were still tweaks that needed to be made or changes that needed to be made.
Okay.
And so that is just as a little bit of background. Hi, Judge Britton.
Hi there. My apologies for being late. I had another meeting.
Good that you're here. Thank you. Okay, that sounds like we want it on the schedule. We're going to see how big or how minute an issue it is that we can address if we need to. The third one is and this is the one that I think we took out. We did take out of order, but whether justice courts should have the option to become courts of record. And I think what we wanted to do on that was to take that up with Judge Britton, Judge Cross, and with Judge Kidd, and see what the issue is and how big the issue is, and whether that we're okay with addressing that in the time frame of January and March. And Judge Britton, we can ask you if those months work for you, because you're the only one here on the calls.
Well, we have Emily Oberdorfer, who's incoming president for OJA, but I don't see Dan.
I
Is that
emailed,
right?
yeah, I have, Judge Cross is not here. I emailed him last night, but I didn't hear back.
Okay. Sorry. And I was listening, but I was multitasking. So the specific, did we raise this issue on the list when we were finalizing the last work group? And this was, I believe, Judge Kidd's idea. Is that right?
And I'm meeting,
Yes.
yeah. And I'm meeting with Judge Kidd either the end of this week or beginning of next week.
Okay. Can we just put a hold on that after those discussions where you can ask him point blank? And
Yep.
then if he wants to pursue that, then we can vet it with our legislative committee.
That sounds like a good plan.
Hi, Jim.
Yeah, I just wanted to point out there are the people who should be interested in this issue are not just the justice courts. The two important features of court becoming a court of record is that you need to become, as a court of record, you need to have some means to record the oral proceedings in the courtroom. So there's the expense of microphones, recording devices, making sure that those work. If there's a jury that has to be incorporated, you have to have some means of retaining those records. And typically the county would have to bear that expense. The other issue is that if an appeal is taken, the appeal goes to the Court of Appeals rather than to the circuit court. That typically means that the state or county interest necessarily has to be represented by counsel. But oftentimes, in fact, if not universally so, the Department of Justice ends up handling those appeals under some sort of contractual relationship. I mean, I'm not sure whether that's by state law or whether they just choose to do so. So the DA's office sort of loses control of those cases because they will not be litigated in circuit court, and they will go up to the Court of Appeals, where the case will be for many months. There's the cost of preparing a brief, the cost of attending oral argument. So both the county and the DA's office have interests here.
Right. Right. I think that's what we talked about originally with the question of cost, and that's why I asked the question about justice courts and who funds them, because I knew there would be an issue we would need to talk about there. Judge Britton, thank you.
If we're only talking about justice courts becoming a court of record, we're only talking about 3 justice courts because we're talking about the 50-mile rule, correct? Isn't this the proposal? Right now, there's a limit. You can't be a court of record if you're within 50 miles or 100 of the circuit court. And so it only applies to 3 justice courts, and none of them hear criminal matters. So we're only talking about traffic and violations.
Okay, and the 3 justice courts would be
Marion,
Marion,
Clackamas, and Washington.
okay.
And none of them have criminal matters.
Okay.
Just to make clear, though, I think the proposal was whether the work group should propose repealing the 50-mile limitation so that virtually any justice court could choose to become a court of record, or any county could choose to have its justice court become a court of record.
Right. And it was not going to be a mandate. It was going to be a discretionary decision based on all those factors you discussed. I mean, I can tell you that I'm a very high volume court of record, and we average like 6 appeals a year, and we do violations and criminal cases. So, I can tell you that this would be a very low volume going to the Court of Appeals in my court's experience.
Okay. And Judge Britton, will you remind me where your court is?
Beaverton.
Okay. So Washington County or Beaverton?
City of Beaverton Municipal Court.
Got it. Thank you. Okay. Okay, so that will be a good, and Kimberly was just saying that she thought also the DOJ would be involved, because obviously if they end up representing the state on appeals to the Court of Appeals, that they might have something to they will have an oar in the water on whether this, how this would work. All right. The next issue was whether violations appealed from the local court to the circuit court, and then the Court of Appeals should proceed under ORS Chapter 19 or Chapter 138. And the proposal is that that get taken up in March and April. And I don't know whose issue this is.
Would be mine.
Okay.
There was disagreement among the work group on the law around that area. So I think we tabled it because we just didn't have enough time to resolve it. Correct me if I'm wrong, Jim.
Yeah, I think the way that came down is that I think an initial decision was made to make the change from Chapter 19 to Chapter 138. That is, Chapter 19 governs appeals in civil cases and 138 governs appeals in criminal cases. So the issue is whether appeals in violation cases are more like civil cases or are they more like criminal cases. And I think the work group initially decided that they were more like criminal cases and it made more sense to go under Chapter 138. But then the representative from the State Public Defender's Office got a little concerned that we didn't know why the legislature originally had them go under Chapter 19 and that maybe there were some kind of cases that would fall through the cracks. And so by that time, we'd run out of time to inquire into that issue. So we decided to postpone dealing with it to this work group.
Okay. And so who, aside from Jim, who would be the people of interest for that?
Dan
You go.
Cross on behalf of the JPs, and then Emily and I on behalf of OJA.
Okay.
I would also like to participate in that conversation.
All right, Heather.
Certainly the Department of Justice, because it's their lawyers who will be handling these cases.
But aren't we talking about violations?
Yes.
Okay.
I would, for the city, I would like to be involved, and Judge Gill couldn't be here. He says his apologies, but I believe he would also like to be a part of that discussion.
Okay.
I know when we've had appeals here out of the city of Eugene, municipal violations, that that's been the city prosecutor's office. And so that's just to say it wouldn't just be Department of Justice that might be affected.
Yes. Yes, I need to correct myself. It would be those cases coming from justice courts that would be handled by DOJ. Those cases coming from municipal courts typically would be the city attorney.
Okay. Is the I think I know the answer to this, but the current violation trial, does it have the same burden of proof as a criminal case or as a civil case? Because I thought it was a civil
Much
burden.
lower.
Civil, yep, preponderance.
It's more likely than not, yeah.
Okay, that's what I thought. So I'm wondering if that might be why it followed the civil path rather than the criminal path.
I based on my research, we don't know why. It was again one of those bills that was offered that made a number of changes, or at least I don't know if it necessarily changed the law. Part of the problem was that had been quite a few of these cases coming up from local courts, and there was a lot of confusion over what the proper procedure was. So I believe it was Department of Justice offered this bill that would make clear some of these issues that the courts had been wrestling with. And once again, there was commentary and written materials on some of the changes, but total silence as to why they chose to have these cases go under Chapter 19 instead of Chapter 138. And so it's that absence of knowing what was the original policy reason that gave us pause. Why are we changing something when we don't know what the original reason was?
Well, is there any reason that we needed to change it at all?
Well, one of the oddities is that even though the statute says that the cases will proceed in the Court of Appeals under Chapter 19, it also says that the scope of review, and there's one other provision, says shall be the same as in criminal cases. Well, the scope of review is kind of the biggest deal. That's the primary difference between Chapter 19 and Chapter 138 is the scope of review. And so once the Court of Appeals applies the same standard of review to violation cases as to criminal cases, then the rationale for having them proceed under Chapter 19 governing civil cases doesn't make any sense.
Okay.
There was also some disagreement on appeal rights on default judgments for a failure to appear. Jim, again, correct me if I'm wrong. I'm not looking at any notes, but I think that was something we were further going to explore because the work group was split on that topic, correct?
Yeah, I think, although I think we came up with some wording that would have addressed that, but that was one of the original concerns. And I think that another one was that there can be ancillary proceedings in some violation cases. For instance, I believe Multnomah County, and I'm trying to recall the example. It's something to do with, under some circumstances, the city can confiscate or forfeit a person's car in connection with these violation cases. And so the question is, are those proceedings relative to the car criminal nature, or are they civil in nature, and should they proceed under Chapter 19 or Chapter 138? And we simply ran out of time to wrestle those issues to the ground.
Okay. Well, it sounds like we have the makings of a committee group based on people expressing interest in the issue. So does it look like that's an issue that we could address in the March-April framework?
Can I just add something really quick? Well, actually, two things. One is we spent a lot of time deciding what the scope of review was for relief from default, and that is explicitly resolved in the bill according to the last work group. But
Okay.
people could certainly take a look at what we did and whether things need to be tweaked. But the other thing I wanted to point out is that this change, at least the way we talked about it in the last work group, was not just for violations that originated in local courts. It would be all violation appeals going to Chapter 19 or 138. So that's something that we should also keep in mind. Is this something we want to change for all violations? And again, I don't know how many, what numbers we're talking about here, but are we talking about all violations? Are we talking about things that originate in local courts? Because, that might change, the people that are interested, the numbers we're talking about, and whether that it's within the scope of this work group.
Okay. And currently, the bill addresses all violations as opposed to one or the other. Is that right?
We left the path of violation appeals alone. We kept it with Chapter 19.
Got it. All right.
I wanted to just add that my recollection is similar around the appeal of default judgment, that there was a lot of conversation about that. And we had agreed upon those not being appealable, just like the decision on whether to set them aside at the motion. So, and I guess I'm just like saying this because we had several meetings about it, and even though the solution wasn't necessarily the one that I advocated for, I think it was a really robust discussion around that, and I didn't understand that to be unresolved.
Okay.
And then also, I think this conversation around whether the violation appeals should be the same, regardless of what court they originated from, maybe overlaps a little bit with another topic on this list, which has to do with whether the limitation on appeals to the Court of Appeals and the prosecution of municipal offenses is unduly restrictive, because there are additional restrictions on appeals of municipal offenses that originate in a municipal court and then go to circuit court and then go to the Court of Appeals. And that's different from municipal offenses that are tried in circuit court in the first place, which is possible. So I guess I'm just saying maybe those conversations might occur together, because there might be some overlap.
Okay. So it may be a conversation that involves all violations as opposed to just violations in one court or the other that initiate.
Whether we think they should be treated differently, depending on where they originated.
Okay. All right, and that kind of takes us to the next question, which is the limitation on appeals to the Court of Appeals in the prosecution of municipal offenses. And so I'm wondering if those, and it might be that, I guess what I want us to be aware of, and I take responsibility for not having been on the work group before, so I don't have the history, and I appreciate when you all who have been involved have that history and share it, because I really don't want us to revisit everything that you spent as long as you spent doing and getting to a resolution. I really don't think that's what we're being asked to do, and frankly, we don't have time to do that either. And it wouldn't be, I think it wouldn't honor the people who work so hard to make the strides they did make and make the changes to the legislation that they did make. So I appreciate you bringing us kind of back to core on what maybe has already been addressed, even if it wasn't to everyone's liking. So with that in mind, I guess the question I have on the limitation on appeals to the Court of Appeals in the prosecution of municipal offenses, is that something that was addressed and there was just a disagreement at some point about whether or not it was too restrictive and then it passed anyway? Or is it something that we didn't get to and that we need to get to?
I don't think we addressed that yet.
We simply ran out of time.
Okay. All right. Fair enough. So who would anticipate us needing to have in the room on that question?
Prosecutors, for sure.
Okay.
Someone from Oregon Judges Association, whether that's Juliet, myself, or our new Vice President, Aaron Zember, is going to want to be on every work group.
Okay.
I anticipate Judge Go will want some interest in that as well.
Okay.
I would like to participate, and then I also am unsure, I haven't looked at our list, but if there are any public defenders participating in our work group this term.
Amy.
So just to answer your question, Heather, I've reached out to Tony Rosta has retired. Rosta has retired, and I've reached out to Maylee Browning, who's the lobbyist for OCDLA, and she is working with Sean to find somebody. I don't believe she's found someone yet, but I can continue to kind of nudge, and try and get somebody here from there because they are interested. I think they're just trying to figure out who that would be.
Okay. Okay, well, sooner rather than later would help.
Yeah.
I would also,
I
sorry,
Go ahead, Melissa.
I think this is one of those things when you're expanding cases, that the city is going to want to be in, like the cities, so League of Oregon cities, because we're talking about expense. Like when you add cases, that's going to be a significant expense for cities.
And Melissa, I've talked to Scott about this, and that is, I think, one of the reasons I think he is back again for the second round. So we've talked about it, and I can reach out to Scott, Judge James, and let him know that
Okay,
this is
great.
a thing. He's not here today, but it's Ledge Days, so.
I'm thinking that these issues are probably going to be some of the most difficult to solve. And I have to say I was a little concerned when I saw these issues kind of toward the end of the list that we wouldn't get into perhaps until April or May. Although if we combine them with the previous one that starts in March, that makes me feel a little bit better. But maybe if we move them up the list a little bit, that would be great. Although, as a practical matter, it may take that long to get everybody on board who needs to be. But I would say the sooner the better. But I think these are going to be tough issues to solve.
Okay, well, the thing about that is that we certainly can find who the stakeholders are, and we also can, using the information that we have from the last the last series of decisions and where things were left, we certainly can start work groups that are not dependent on this schedule, but can predate this schedule. We can assist you in preliminarily setting up meetings earlier than this. We're just concerned that February is a legislative month. It's when the legislature is in session, and it tends to not be a time that people are very able to, to participate. So we didn't want to presume that that would be a time frame we could work in. And so, it is true that if we can address the justice courts and the courts of record issue, in January, that we could get into this as early as as March. So that's probably as early as we'll be able to see it, given that we have the holidays coming too. Amy.
And I just wanted to flag that I am aware I didn't schedule something in February, as you guys saw, but I'm happy to assist in scheduling small groups in February. The commission does not have a legislative package going forward in 26, so I am available to do things. I'm mostly thinking about people like Kimberly and Jessica and Lindsay and Matt, who are going to be busy. So I just wanted to flag that for those folks. But I'm happy to assist with that, and if that's something that people want to do, and to use that month for small groups.
Thank you. I think that would be a great idea. Okay. The next question is whether the records of abolished local courts should go to the circuit court or the city or county. And I don't know if we have abolished local courts, and that's why this is a question, or if we don't.
Judge, this was raised by Judge Briston in Clackamas County, and I think it happened one time, and so that's why it was raised. I mean, it's fair to say that there will be local courts that eventually will close, and I think we just want a clarification on where the records go. But
Okay,
it's definite, when we talk about priorities, this is definitely not a high volume occurrence. It does not need to
okay.
be a priority in my mind.
Okay, so it might be that what we can do is have a small work group. Lindsay.
Hi, I just wanted to note that OJD was interested in this provision as well. Currently, the House Bill 2460 took the current law, which says that if a justice court is abolished, the justice of the peace record should go to the circuit court. And so it doesn't happen a lot, but it's just logistically, create some questions to have that in the law about what would happen and how would that transfer occur and all of those things. And so the work group didn't get into those details before, but I think we are interested in kind of problem solving that before it comes up.
Okay. And when it's not a court of record, what are the records?
Those would be things like the abstracts, any letters that went back and forth between the court and the defendant. What else did we have? It would primarily be that abstracts and then stuff from city ordinance cases.
Okay.
Maybe there's also a list in the statute itself of items that have to be transferred over to the circuit court from the justice or municipal court when there's an appeal. So I guess it's all those things.
Right, but if there's not an appeal, what happens to those? I mean, I just am curious whether or not they purge
Yeah.
records.
I just mean that probably provides a list of the sorts of things that they would have in their records.
It's very vague. And the for violations, we keep them for, I think it's 5 years, and then everything gets destroyed. For crimes, it's 10 years, and then it gets destroyed. And for violation of city ordinances, I would have to check with the city recorder. But
Okay.
she's the one that handles all of that for the city of Tigard.
Okay.
And we just became a court of record last year, so
Okay.
this is all somewhat familiar in my mind.
Okay. All right. Well, it sounds like that's something that we could do with like a smaller work group perhaps, and see, if there's a clean procedure for that, what it would look like, and whether or not there would be whether it's something that people can agree on, since it sounds like it's a rare occurrence. And it sounds like we could handle that with some dispatch, I would hope. Okay. All right. And then I'm actually wondering if the last one, the when and how to transfer cases between local courts and circuit courts, I am assuming that transfer happens already. So I don't know if there's no process for it, or if, and that's why we're being asked to look at it, or if there is a process and it is confusing.
I thought we just hashed this out at the bill that just passed, or are they talking about when courts close?
No, that's a different question. So that's why I'm asking.
Yeah, I mean, we just hashed the logistical details of transferring documents in the last work group. I feel like that was settled.
I thought so too, Judge.
I think we're talking about two different things. If we're talking about when an appeal is taken, moving the record from the local court to the circuit court, the bill addresses that. What I think we're talking about here is Judge Kidd of the Marion County Justice Court informed us that as workload issues, sometimes the Justice Court and the Circuit Court move cases back and forth. So if the Justice Court has a huge overload, they can transfer some of those cases to the Circuit Court if it has bandwidth to deal with them. And likewise, if the Circuit Court is overburdened, it can transfer some of those cases to the Justice Court to be heard. My understanding is that this is being done now, and it seems to be working fine. My concern is I don't see any statutory authority for it. And I do really, I mean, I think it's a great thing, and I think it may be an opportunity for other courts to share the burden when there are unusual either increases in cases or lulls in cases to kind of even out the workload. So I think it sounds like it could be a really good thing. It's just that I don't know that there's statutory authority for it, and the statutes don't address the logistics of when do you make the transfer, who gets notice of the transfer, does the defendant get the opportunity to object because they thought they were going into justice court, now they find they're going into circuit court, or vice versa. So I think there are some issues that need to be sorted out there.
Well, can we just figure out whether or not anybody's doing it other than Marion County's Justice Court and Marion County Circuit Court?
When we do it in our county, there's a dismissal of the initial court filing and then a reissuance of the citation and filed in the new court. And there's certainly statutory authority to do that, but that's how we do it in our county. It happens sometimes when maybe it's discovered that the DUI should have been filed as a felony, not a misdemeanor, or there's lots of variety of reasons. But that's kind of how it's happening in my jurisdiction. It's rare though. Again, when we talk about priorities, I'm not sure this is top in my mind.
Okay, well, we have it listed as last, so that might say something. And but it might be also that if there is a practice that happens, and if it's done and you have a system that works, and if somebody else has a system that works, but we just don't know if it's in a statute or if it's in a letter of understanding or something, a memorandum of understanding, then maybe we have to find out how it is that they do that. And if there's a practice that needs to be codified, I suppose that's one way that you could put it into statute by saying, let's do it the way we always do it, and just make sure that it's in the rules, in the statute somewhere, so people know why we're doing it and that we can. But I don't know, I mean, if we can get to it, maybe we'll get to it, but I'm not sure that we want to, if it's working just fine, I'm not sure we want to go in and try to change something that's working. But maybe we could get some clarification as to how it actually operates and whether or not there's any heartburn from any of the stakeholders on how it's currently being accomplished. And then know that. The one that I did skip was the question of whether the city of Portland should have a municipal court system. And this is not something that we were asked to do by the work group, but it is something that John DiLorenzo raised. And I guess my question for this group is whether we feel that we have the right. Kimberly, I'm sorry, I didn't see your hand, and I don't know if you want to talk on the thing I just talked about or on this one. So
on this one, but why don't you go ahead and finish what you were saying?
Okay, what I was going to say was that I'm not sure, that this is in our kind of original mission statement, but B, I'm not sure that we have the right stakeholders here and for deciding this. And I think it's a big issue of city governance for a particular city. And so I'm not sure that it's something that the Oregon Law Commission should be jumping into either as the commission whole or as the work group small. So that's my personal concern about it.
Well, Judge, you just said perfectly exactly what I was thinking. This seems like a local conversation. It's among the Portland City Council and the Portland District Attorney and the Portland defenders and the Portland petitioners who practice in Portland in the civil area. Like, it just seems like this is a local and also the local circuit court. I think that if this is something that folks are really interested in, that there should be conversation amongst those stakeholders. It does not seem like the kind of thing that the legislature should be dictating to this city of Portland.
I think I'm seeing a lot of thumbs up, and so I'm willing to entertain anybody who feels strongly otherwise.
Just
and I'm not.
just to be clear, there's nothing statutorily preventing Portland from having one. It's just some sort of a handshake agreement from long ago. So I'm wondering what would even be in a bill.
Jessica,
because it would just be like a legislative finding.
There is a statute that in chapter 1, and I can find it, that has to do with cities over 300,000.
Oh, okay, got it.
But yeah, I mean, it's one of those things where you're like, when it's written, it's like, oh, clearly we're talking about Portland, even though we're not saying Portland. So
yeah. So if you all are okay with this, I am going to suggest that we let John know that it's not something that's inside our bandwidth as a work group on this issue specifically, and that it would take a lot more people at the table and probably take less of some of us at the table, and that might answer the question for not necessarily being something that we are willing to take on. And I'm also especially mindful of, of the concern that some of these issues, are going to be thorny issues that we want to spend time on. And so I want us to be able to spend time on the things that we know we've been asked to address. So if that's okay, that's the approach we'll take. Okay. All right. Well, I don't want to keep you later. It's a little bit after 1, and I do like meetings that don't last more than about an hour. So, and I'm also seeing great chats. And Amy, is it possible for us to save the chats so that we can have them?
So the way it works and I just learned this recently, if you chat the entire group, it will be saved. But if you send something individually, like if you send a note to me saying, Amy, what the heck are you talking about? That will not be saved. Okay. So if you send something to everyone, then it does record and I do have access to it.
Okay, great. Because I'd like to spend time on those, and I'm not very good at multitasking, but I'm trying to keep an eye on them. Okay, and there's some good suggestions for referencing some of the issues that we've talked about as well, just to refresh our memories. Everybody, thank you so very much. What I'd like you to do, if you don't mind, is let Amy know specifically the issues that you want to work on, so that when we're setting up, especially our next set of small groups, that we can get everybody who wants to be at the table. And if you believe there's somebody that needs to be at the table that we haven't identified or that is just not able to be here today, please give Amy that and Kara that information as well. And we can then make sure that we can have like the best opportunity to have a robust discussion and come up with some suggestions. I do have just if you don't mind taking just a couple more minutes. I know that there was the work group was working on the FED undertakings and the waiver process, and whether or not there should be a waiver process. And they met yesterday, and I had a couple of short questions. But Jim, I was hoping that you could give us kind of the thumbnail of maybe what your work group wants direction from this group on, if that can be accomplished today.
Okay, sure. One thing I should note is that probably the scope of that first issue needs to be expanded. It currently says whether there should be a waiver process for FED undertakings. And one of the first issues that we realized is really, should there be a waiver process for undertakings generally, which would include undertakings for FED cases. So and we talked about there is an undertaking process and waiver thereof for civil cases going from the Court of Appeals, going from Circuit Court to the Court of Appeals. That makes sense because those cases are going to be there for months, if not years. By contrast, it appears that appeals in civil cases from justice courts go to circuit court and are resolved, in our experience, probably within 30 to 60 days. And so there isn't quite the same urgency for undertakings or perhaps waivers thereof. The issue also arose in light of how short the period of time is, and that an undertaking puts a burden on the appellant, many of whom are low-income pro se people, whether we need to have an undertaking at all, particularly in FED cases. Part of our problem is that most of the people who participated in the meeting either work for the state or for the judicial department, or like myself, we have no dog in the hunt. The primary stakeholders are the plaintiffs' lawyers and defendants' lawyers. Heather Merrick ably defended the interests of defendants, but we didn't have anybody who could speak from the point of view of plaintiffs, either in civil cases generally or especially in FED cases. So part of what we're doing is, and I believe Amy's working on this, is getting a representative from the other interest group up to speed as to what the issues that we are wrestling with. And so kind of the issues are whether we need to have a undertaking at all. If so, whether there should be some sort of opportunity for a judge to waive or reduce the amount of the undertaking, and if so, what should be the standards?
And when you talk about the undertaking, are you talking about like the filing fee, or are you talking about the amount of the judgment, or both, or
So the law in this area with respect to appeals from circuit courts covers both the undertaking for costs and an undertaking that would be used to stay enforcement of the judgment pending appeal. And we have to say, and if we are to impose, and current law does require for appeals from justice court to circuit court that the appellant file an undertaking for costs, and the primary cost would be the circuit court filing fee, or perhaps the only cost would be the circuit court filing fee. So yes, we are talking both about the undertaking for costs and supersedious undertakings.
Okay, and when you're talking about FEDs, are you talking about staying the judgment, as in, because there's a big process that goes through in getting somebody out, say, of a house where they haven't paid rent. And the question is, if you go through that whole process and you're entitled to a sheriff's order or a sheriff's assistance to get the person out of the house, if the person files, are you talking about that they would not have to file anything in order to get a stay of being evicted?
That would be one option. The other option is what the House Bill 2460 sets up as a new process, which is that the tenant would pay the fair market rental value of the premises into the court on a monthly basis, or whatever the periodic basis that the tenant had been paying. And that, so long as the tenant timely pays that amount into the court, the enforcement of the judgment is stayed.
Okay. All right. So it does sound like you would need to have people involved that are on both sides of that issue, because I know that's just, I know there was just a lot of angst and a lot of education around the whole FED process that involves people of low income, there was a lot of change to the statute as a result of COVID. And I know how much time that took and how many people at the table it took. And so my concern is I'm not sure that we have the time or bandwidth to be able to address that in our time frame that we're setting for ourselves.
Yeah, I mean, it's certainly possible that we will find out that these issues are intractable. But it's also possible that we will be able to come to some sort of solution because, as I said, there's already a model in place for civil cases generally, including FED cases, going from circuit court to the Court of Appeals.
Right.
And so if we decide that undertakings should remain, and if we decide that that a judge should have the authority in appropriate circumstances to waive or reduce those, we already have a model of what the statutory language is going to look like or could look like.
And we're
Okay.
not, I don't think that this small group or that this discussion would be contemplating changing any of the underlying timelines for FEDs or other kinds of procedures. So, I mean, I think there was some discussion about how, like, the interplay between the waiver motion and then and how that works with the expedited timeline in an FED case in particular that's coming out of Justice Court, but we're not suggesting that we tamper with any of the statutes that the various stakeholders worked on
Okay.
COVID and after.
That's good to hear. That's reassuring. Thank you, Heather. Okay. All right. Is there anything that your small group needs from us before the next time you meet, Jim?
I don't think so. We just need to get the proper folks at the table and hash these things through.
Okay. All right. Well, thank you. Thanks. I appreciate you filling us in on that. Amy, anything else for the good of the order?
I'll reach out to the small group again and let you know what I hear from Anna McCormick. Our next meeting is December 17th, I think. And if anyone needs anything, please let me know. And we'll send the recording and the materials out in the next few days or so.
Okay. All right. Thank you all so much for giving your time to these issues. Have a great rest of your day and happy Thanksgiving, everyone.